The Delaware Supreme Court is hearing an appeal from former DuPont manager Esquire Pardo, who is appealing convictions of manslaughter and related charges after a hit-and-run accident that killed cyclist Philip Bishop in Hockessin in 2014.
It's 9 o'clock at night. Mr. Pardo was 1/3 of a mile from his house. He is on a road that is curvy with no shoulder, and he has 3 young children in the car. He thinks he hits a branch. His windshield is shattered, but he can still see through it enough to go home. Okay, so he drives the 1/3 of the mile to his house. Okay, and that's where he assesses the vehicle. He sees that the windshield is cracked. He sees that, or he doesn't see, there's no blood, there's no visible, from the garage, there's no visible evidence that he struck a person.
Julianne Murray represents Pardo.
The next morning, it was on the news that someone had been killed the night before, that they were driving an Audi. And, he did call, and he said, I'm driving an Audi and I struck something last night.
Pardo was sentenced to 8 years in prison. Murray says there are 2 reasons they're appealing the lower court's ruling.
One is that the court considered evidence, the lower court considered evidence that it should not have considered.
During his first trial, a statement by one of Pardo's sons was admitted.
It was actually triple hearsay, which wouldn't be permissible under the rules. And this lower court used that evidence in its verdict. And whenever you have a case where they use evidence that they're not supposed to, you have to analyze whether it's harmless error or whether it's reversible. And in my view, this is reversible error.
She says it's significant
because this is the only piece of evidence, or the piece of evidence, that suggests Mr. Pardo knew he hit a person.
There was, in fact, plenty of evidence to convict him, absent that statement.
Deputy Attorney General Andrew Valla.
There is other evidence of his knowledge. This isn't the sole evidence. This is a small piece of that evidence, because the facts themselves, his admission to driving on the wrong side of the road, the debris field, and just the physical evidence itself.
The second reason Pardo is appealing.
If you're going to be convicted of a felony and up to 5 years of imprisonment, that the driver must know that the accident involved or resulted in injury or death to a person. And I realize, this begs the question of how someone could not know that they hit a person. And my response is that you would have to know Brackenville Road.
It's clear that what the purpose of the law is to impose a duty upon a driver to do just that. Get out of the car and check to see what you hit, whether it's property, or whether it's a person, or whether you don't know. You're obligated to go and find out.
Thank you for your excellent arguments. We'll take the matter under advisement.
Thank you.
In Wilmington, Lauren Hewitt, 101.7 FM, 1150 AM, WDEL.